I'm dealing with the affairs of a loved one who passed away in San Diego County. Do I have to go through probate court, or are there any alternatives available to me? I'm Michael Jenkins, and as a probate attorney in San Diego County, it's a conversation we have most days, unfortunately. Now, in our Probate Roadmap Call, we'll typically discuss this with you in a more individualized fashion based on what it is you're working through, but I wanted to put a quick video together to help you understand how we triage these cases and what are the concepts that go into deciding what the best path forward would be. Now, in any estate administration case, it all starts with what are we dealing with? What are the assets that were left in the individual who passed away in their name? And perhaps more importantly, was there a plan for these assets or not? And that's sometimes the million-dollar question. If there was a plan, most of the time, it's not going to be such a big deal in doing the estate administration. Now, that plan can look a little different from person to person, but commonly on this yes side of the equation, you'll see a trust that was in place and all the assets were in the name of the trust. Or maybe there wasn't a trust in place, but the person who passed away, all of their assets had a beneficiary designation on it, and the beneficiary outlived the decedent. So these types of administrations, generally, you're not going to need probate court involvement, not even really going to look at alternatives. If it was in a trust and the trust was properly funded, we just administer the trust according to the terms. It's private, around the kitchen table, no court involvement, generally. If there's beneficiary designations, we submit a death certificate to the institution. They may have an internal form to fill out, but there's generally not going to be any court involvement. Now, one thing that trips up a lot of families is they assume, okay, they were assets in the person's name who passed away, and they did a will, and we found the will, so there's a plan, right? We'll just follow the terms of the will. Unfortunately, while that's true, we'll ultimately follow the terms of the will, it doesn't belong on this easy side of the equation. So I'm going to lump that over to this side. If there wasn't a plan in place, that avoids probate court, to be clear. So if someone passed away and they had assets in their personal name, not in a trust, there was no beneficiary designation on the account or on the asset itself, even if they have a will, we're on the not avoiding probate type of plan side of the equation. Now, on this side of the equation, it's going to get a little bit nuanced. If we've determined that there's not a probate avoidance plan in place for whatever the asset is, the next thing we're going to do is look at the value of the asset and the type of the asset. And what we're talking about when we look at the value and the type of the asset is we're trying to determine, do we have to take this estate through general probate, or are there alternatives available? And we hope and pray we can find an alternative so that we don't have to go through general probate. Now, when we're going through alternatives to general probate, we're just trying to find an easier solution than the general probate route. And there's 4 big ones that we always want to see if we can qualify for before going to general probate. The first one is the easiest one. It is a small estate affidavit. Small estate affidavit doesn't have to go to probate court at all, actually. It's totally outside the court system. And what it is an affidavit that someone can sign saying, I'm the rightful heir, please give me this account. And the account is ultimately transferred to them or paid out to them. Now, the value threshold for this small estate affidavit will depend on when the person passed away. If they passed away after April 1st of 2025, it's going to be $208,850. Prior to April 1st, 2025, going back a few years, it's going to be $184,500. Prior to that, $166,000 and change. It ultimately will depend on when the person passed away and when you're making the claim as to the threshold that you can claim using the small estate affidavit process. So if we have a small type of financial account that we're claiming, small estate affidavit's great. And if that's all we're claiming, we can do that pretty simply, again, without even going through the court process. The next big petition isn't going to be right for everybody, but it's something called an 850 petition, or sometimes called a Heggstad petition. Now, this is when we have a case where someone did a trust, but they didn't put the assets into the name of the trust, or they didn't have the trust named as a beneficiary designation. But in that trust, they said something like, 123 Main Street should go to my kids. Or they listed the house, 123 Main Street in this example, on the schedule of assets of the trust, but they left the deed in their personal name. Super common, especially in the era of DIY or cheap legal type products out there. A lot of people unfortunately get a trust, but they don't know how to fund the trust. So in that case, we can take a look at the trust and see if it qualifies for this 850 or Heggstad petition. It's a lot nicer than general probate because what we do is it is in the court. We have to write a petition to the court, but we tell a judge, hey, Your Honor, they wrote a trust and they clearly intended that this particular property be part of the trust. They just forgot to move it into the name of the trust. And with your permission, Your Honor, we would like to move the asset into the name of the trust. So we write it, we submit it to the court. It is a hearing in court, but it's just one hearing. It'll take generally 4 to 6 months to get into court, but we don't have to do the typical 12 to 15 month general probate process. So it still is a lot simpler. The next option that we'll want to talk through or run down is something called a spousal property petition. Spousal property petition is when a spouse passes away and they had the home in their personal name. It was community property, but maybe due to financing reasons, it was just easier to do the financing in one spouse's name and the other spouse never got added to the title of the property. We see that pretty commonly when one spouse works or is the breadwinner and the other spouse is at home. Sometimes for financing reasons, they close on the property in one spouse's name, but if they pass away and the other spouse isn't on title, the other spouse doesn't own the property. A spousal property petition is similar to the 850 petition. We submit it to court and it's a one-time hearing. And we tell the judge, look, Your Honor, this is very clearly community property here. There was intent that this pass to the surviving spouse. So with your permission, Your Honor, we want to retitle this property in the name of the surviving spouse only. Now, there's more to it than that, but in general, if those facts play out and it's not separate property that's going to be split between the spouse and the kids or anything, we can utilize that instead of general probate, but we can only claim what will be passing to the surviving spouse through that simplified petition. Now the next one, and this one is more relevant this year than it has been in the past. It's going to be what I'll call a primary home petition if the home value is under $750,000. The actual petition name is longer than that, but this is the gist of it. It's the same kind of thing. We can write a one-time petition to the court if the probate referee, who's just an independent appraiser tied to the court, if the appraisers appraise the home and it's under $750,000 and it was the primary home of the person who passed away, the primary home petition is a powerful new tool where we don't have to go through general probate if the only asset that we're dealing with is this primary home that's valued under $750,000. Now, we've always had a petition like this in the probate code, but in the past, the value of the home had to be very, very low. And it was essentially just that nothing in San Diego County ever applied to this petition or very rarely. With the value now at $750,000, it's likely over the next few years that a lot more homes can go through with this petition. Now, there are caveats to this petition. It's the same thing. It's going to take about 4 to 6 months to get on the other calendar in the probate courts, but it is a one-time petition. Now, one thing we have to discuss pretty heavily, especially as it relates to this new petition, but frankly, as it relates to just about any of these alternatives, is going to be family dynamics. The primary home petition is great because it's simplified to pass the home to all of the natural heirs, but they all have to be on the same page. They all have to join this petition, agree everybody's going to be an equal heir, and then ideally agree with what happens to the property after it's in everyone's name. So maybe we use the primary home petition, we get it into everybody's name. Let's just say there's 3 kids in this example. So in that case, we avoided probate court by using the simplified petition, but because we don't have an executor to make the decisions, everybody's got to agree. And if they don't agree, we may end up in civil court with everybody suing each other now as property owners. The other thing to consider with the primary home petition is while it can be a little faster as far as total time goes, it's not the fastest if there's a distressed property that has to be sold. In the case of a distressed property that has to be sold and we don't want to carry the property, sometimes general probate's still the better option because we can get an administrator appointed in about 30 days in a lot of cases who can then sell the property and deal with it, whereas the primary home petition is going to take 4 to 6 months to get in. May not make such a big deal in most cases, but it's something to talk through in deciding what option is best for you. Now, if general probate is the answer, it's what fits in the scenario, all's not lost, okay? Probate is not fun, but with the right counsel behind you, it also doesn't have to be the monster that it's made out to be. It is 12 to 15 months. Sometimes it can be 9 or 10 months in the cleanest of probate cases. But with the right counsel on your side, it should really feel like a hurry up and wait thing more than anything else. The attorney will do the heavy lifting and make sure that you're moving through the process as efficiently as possible. Now, if you're dealing with the estate of a loved one who passed away in San Diego County and you're just not sure what fits for your scenario and you'd like to discuss, we do offer a free probate roadmap call where we'll go through and do this triage with you based on your unique scenarios. This is a high-level overview. There's a lot more that goes into it, of course, especially with family dynamics at play. That can totally change everything. So if you'd like to have that conversation, please feel free to give us a call, send us an email. We're here. We're happy to help.